Minister Edwin Tong.
Mr. Speaker, I thank the members for the support of this bill. Overall, I've heard the members' comments, some questions as to its operations and processes, but there's been overall support, and I'll address those questions in turn as best as I can. Mr. Murali asked why we have proposed to retain the definition of foreign state in the Extradition Act and whether we could consider listing the foreign states in a schedule in the Act or by way of a subsidiary legislation. So in every review, we must consider what is outdated, what ought to be changed, and what still continues to work well, and of course, making the changes and then retaining those that continues to work well. The definition of foreign state is one such instance which continues to work well for our present purposes, with slight adjustments. The definitions that we have retained had been previously updated in 1998. Mr. Murali mentioned that the definition of foreign state includes a foreign state which had a treaty with the British Empire at the time when Singapore was part of it, and that this could cause uncertainty as to which foreign states may be held to be able to invoke the extradition processes under the Act. So let me clarify that this is not the case. It has been previously clarified in this House that whilst it is true that before Singapore's independence, there were extradition treaties entered into by the United Kingdom and other foreign countries in which Singapore was listed in the scope of operation of these treaties, it does not follow that today all those arrangements automatically apply to Singapore. In fact, these pre-independence treaties will only apply where the government has considered that these treaties are binding on Singapore and where we have published this in subsidiary legislation, as Mr. Murali has suggested. The short answer, therefore, to Mr. Murali's question is that only our pre-independence treaties with Germany, entered into in 1935, and the US, entered into in 1872, apply to Singapore. The relevant treaties are published as subsidiary legislation in the Federal Republic of Germany Extradition Order in Council and the United States of America Extradition Order in Council. None of the other pre-independence extradition treaties entered into by the UK currently apply to Singapore. Mr. Louis Ng asked for clarification as to why there are special restrictions on surrender to declared Commonwealth territories, and also why in general do additional restrictions apply in cases where Commonwealth countries request extradition. He has also asked about the significance of Section 28, which provides that offences against the life or person of a political figure or a member of the political figure's immediate family are not offences of a political character. Let me give a brief explanation on how Section 28 operates. The Act contains an existing restriction on surrender in Section 9, subsection 1, where a fugitive is not liable to be surrendered if the offence is of a political character. Section 28 provides exceptions to this restriction. In other words, the political character restriction does not apply in respect of an offence against the life or person of a political figure and his or her immediate family for declared Commonwealth territories. The fugitive may be extradited in such a scenario. This specific carve-out to the restriction on surrender is adapted from Clause 12, subparagraph 2A of the London Scheme, which, as I earlier mentioned, would only apply for declared Commonwealth territories. For completeness, the member also observed that there are additional restrictions that apply to Commonwealth territories and not to foreign states. These additional restrictions are where the offence was committed outside the requesting state and Singapore is not an extraterritorial offence under the law of the requesting state, and where the person has become immune from prosecution. The reason that these additional restrictions apply for declared Commonwealth territories is because these are aligned with the London Scheme. That said, it is not the case that where a request of such a nature is made by a non-Commonwealth territory, that such a carve-out to the restriction or surrender for offences of a political character would never apply. For all foreign states and territories that are not part of the Commonwealth, the bilateral or multilateral treaty in place would be the primary source of our international obligations to each other in relation to extradition. And I think this also addresses Ms. Lim's point about what we do with the new treaties, including that with Indonesia. The treaty terms would prevail. Some of our bilateral and multilateral treaties contain a similar provision. For example, I pointed out earlier that the International Convention for the Suppression of Terrorist Bombings makes it clear that a terrorist bombing offense is not an offense of a political character. Singapore would similarly be obliged not to restrict the surrender of a fugitive to the foreign state or territory in the event the offense was the bombing of a political figure's residence. On this note, this brings me to Mr. Murali's query on how the shift to the threshold approach for extraditable offences would be reconciled with our bilateral treaties which adopt the list approach. I think several members also touched on the question of how you might reconcile this in the context of having a treaty and also the impact that this bill might or might not have. I mentioned that Singapore's existing extradition treaties would be the primary source for our international obligations to foreign states and territories. Saving provisions have been drafted in the bill to preserve the status quo in our existing extradition treaties, which means that amendments would generally not apply to our extradition treaties. Where applicable, however, the threshold approach could, in some cases, widen the scope of extraditable offences under our bilateral treaties and arrangements. However, this is not the case for the example which Mr. Pillay cited vis-à-vis our bilateral treaty with the US. The US would not be able to rely on the bilateral treaty to request extradition of a fugitive wanted for an offence that is not within the categories of offences in the treaty. This would respect the fundamental principle in international law that the ambit of the treaty governs the obligations between the states. Mr. Ng also asked whether we could share scenarios on how the ministerial discretion is meant to be exercised in deciding to accede to or reject an extradition request. I think Mr. Dennis Tan, I think, also touched on a question of when the magistrate might order the release of the fugitive. To deal with this point, for instance, when would the minister choose to extradite a fugitive even when his or her remaining imprisonment term is minimal? I mentioned earlier in my opening speech that there may be instances where the surrender of the fugitive is nevertheless warranted, even if the remaining imprisonment term might be minimal. For example, there might be significant public interest in the requesting state or territory for the return of that fugitive. And in such a scenario, we might decide to accede to the extradition request even if the requirement for the discretionary restriction has been met. Let me touch on Mr. Ng's queries on the use of summarized evidence and the case mechanism. And he also asked what mechanisms are in place to ensure that the summary of evidence is sufficient for the minister to make the required determinations under the Act. I had explained earlier that a record of the case mechanism simplifies the procedure for admission of evidence to justify the extradition of a fugitive. For example, it may suffice for a prosecutor of the requesting state to summarize the circumstances of the fugitive's arrest rather than to include numerous affidavits from each witness and every arresting officer to describe their individual roles and capacities in which the fugitive was apprehended. It provides an alternative means to presenting evidence, but does not in any way mean that the bar or the standard of evidence has to be reached for the threshold for assessment of committal for this fugitive is to be lowered. There must still be sufficient evidence to prove a prima facie case. In other words, on the face of it, that there is sufficient corroborating evidence that the fugitive indeed committed such an offence. The Attorney General's chambers and my ministry will ensure that every extradition request is sufficiently substantiated with such evidence before we accede to the extradition request and commence committal proceedings. At the committal proceedings for a magistrate, the magistrate would similarly need to be satisfied of the prima facie evidence requirement before the person can be committed to prison to await their surrender to the requesting state. Mr. Ng raised, as an example, the restrictions of the minister's power to order a person's surrender if the minister has substantial grounds for believing that a person will be prosecuted for reasons of race, religion, sex, ethnic origin, nationality, or political opinion, and what mechanisms would be in place to ensure the summary of evidence is sufficient for the minister to ascertain that such grounds exist. So let me explain. Generally, if there's reason to believe that a person is going to be discriminated against or prosecuted along one of these discrimination grounds, then you're unlikely to find that the evidence submitted by the requesting state would detail this. On the contrary, if there is a dearth of credible evidence in the extradition request justifying the commission of the alleged offence by the fugitive, this could form a basis and contribute to the grounds for the minister's belief that the fugitive is being discriminated against or that one of the restricted categories might apply. For completeness, we would add that Singapore has always required extradition requests from requesting states to also contain undertakings that the fugitives would not be prejudiced or otherwise punished by reasons of race, religion, nationality, or political opinions. This requirement will remain even with the introduction of the case of the record of the case mechanism. Mr. Murali asked why the magistrate's power to issue warrants of arrest is by a notice by the minister is being retained. Let me explain what this contemplates. So the reason for the retention of this power is for provisional arrest. Provisional arrest is a procedure that applies for urgent cases where a requested person is deemed to be a flight risk and there is insufficient time for the requesting state to prepare a full extradition request. As Mr. Pillay mentioned, it is preferable and indeed is required for any foreign state or territory to request the extradition of a fugitive through a formal request or via diplomatic channels. However, there are sometimes cases where there is information that the fugitive is a flight risk and there is an urgent need to detain the fugitive to prevent him or her from fleeing. This allows Singapore to fulfill our international obligations under our treaties. And so in such cases where the overriding concern is to ensure the detention of the fugitive, the quickest way would be for the magistrate to have the power to issue warrants of arrest without being authorized by a notice by the minister. Subsequently, a full extradition request must be submitted by the requesting state within a fixed number of days, and the number of days depends itself on the terms of the treaty, and in any event within reasonable time. If, for example, the full extradition request and the supporting documents are not furnished by this time, or the documents are inadequate, or if any of the restrictions on surrender apply, the minister can then direct the warrant to be cancelled. So in this case, after the initial arrest notice has been issued, it subsequently transpires that upon review of the full set of extradition materials from the requesting state, these thresholds for committal are not met, then in that scenario, the minister can ask for the warrant to be cancelled. And to Mr. Tan's point, it is also in that scenario that if the magistrate is of the view that a threshold has not been reached, has not been crossed, then in such a situation, the magistrate can order a release. Mr. Pillay asked whether a Singapore court has the discretion not to grant an order which goes against Singapore's public policy. So the short answer to this question is no, but let me explain this. Under the Act, a magistrate is only entitled to commit the fugitive to prison if the magistrate is satisfied that there is sufficient reason and evidence to justify his or her extradition, or the magistrate has to release the fugitive in all other circumstances. I made that point earlier. In other words, as long as there's prima facie case that would justify the trial of the fugitive, or sufficient evidence that the fugitive had been convicted of an offence, the magistrate must order the committal of the fugitive. Having said that, in the event that the extradition request from the requesting state does indeed go against Singapore's public policy, the minister can consider if this would fall within any of the restrictions on surrender which have been enhanced in this bill. All of these would be grounds on which to refuse the request for extradition. Mr. Murali asked who can make applications to invoke the powers of the court under the Extradition Act. Since extradition requests are made solely at a government-to-government level, as Mr. Murali alluded to, court applications under the Extradition Act would be made by officers from the Attorney General's chambers. The new Section 50 provides that the Attorney General may delegate to a public officer any of his or her powers under the Act. And in the explanatory statement, members will see that it is elaborated upon that a public officer so empowered may act for the Attorney General in court proceedings. Mr. Murali asked about the arrangements with Malaysia and Brunei and why the reciprocal arrangements with Brunei for the endorsement of arrest warrants is not included in the amended Act, and also asked about the legislative intent in relation to a magistrate's powers under Section 121 of the CPC. As I mentioned earlier, aside from minor updating of the language, we have preserved the part on extradition to and from Malaysia. This is in Part 6 of the amended Act by way of endorsement of arrest warrants. In practice, the Singapore and Malaysian authorities have largely relied on Section 121 of the Section 121 CPC procedure, which, as Mr. Murali mentions, covers the same subject matter of the reciprocal endorsement of arrest warrants. Mr. Murali spoke about the special relationship with Malaysia and Brunei, and I think his own experience shows that the officers on both sides, on all three sides, are aware of this and use this procedure. It's been simple and expeditious. And our operational agencies and their counterparts have some history and share a good working relationship on the basis of this established procedure. As I earlier alluded to, time is often of the essence in such matters where a fugitive is a flight risk, and familiarity with this working process, the good working relationship on the basis of Section 121, is being retained. And so therefore, since the Section 121 procedure is used more often in practice, we decided that it was not necessary to replicate this procedure for our arrangement with Brunei in the Extradition Act. On Mr. Murali's ancillary question, a magistrate's powers under Section 121 of the CPC are self-contained. In other words, the magistrate would not need to have regard to Part 6 of the Extradition Act. Ms. Lim raised, I think, 2 points and 1 comment, if I'm not wrong. Let me address them. First, she asked if this represents a shift or a change in approach. The short answer is no. We've always been desirous of looking at countries which have a common desire to work with us to strengthen comity, to strengthen international collaboration on apprehension of criminals, and to strengthen bilateral cooperation in combating crime. And to the extent that these arrangements are seen to be mutually beneficial, works for us, and that we can overcome any issues related to the divergence of our respective legal systems, then we will be prepared to enter into treaties or arrangements with them. On the second point concerning, I think it was restrictions, time bar, if I'm not wrong. If the position is such that if the offense is time barred in the sense that that foreign state is unable by reason of the time bar to prosecute that fugitive in the foreign state, then we will not allow the extradition on the basis that it would have been a futile extradition because you can't prosecute that fugitive. As to why 18 years, that was the request in the treaty, and we acceded to 18 years. It could have been some other period of time, but this was the consensus agreed upon with Indonesia concerning that treaty. Mr. Tan asked several other questions. I'll just deal with them quickly before I end off. As far as the point on military law is concerned, if the offense that the requesting state seeks to extradite a fugitive for is only a military offense, then such a scenario would not result in the extradition being permitted. In the course of apprehending the fugitive, there are search and seizure provisions. These are, as I pointed out earlier, for physical items. But if this leads to other avenues of other evidence which suggests that there have been, as Mr. Tan puts it, proceeds of the crime and so on, then the relevant investigations will entail on the evidence which follows such proceeds. I think I've dealt with Section 16 as to when the magistrate will order the release. And finally, in relation to the question of the spike, I think I've also dealt with that. We don't expect there to be an unusual or heavy spike. But of course, with the provisions here, we will have to look at what the caseload might turn out to be. Don't think this will be something that's extraordinary or anomalous. But as I mentioned in my opening speech, our experience has been that states will continue to seek extradition for the most serious of offences, cases in which there is a significance or for which the fugitive is to be apprehended for serious offences. So on that basis, we don't expect there to be an extraordinary spike given these amendments. So with that, I beg to move.
The question is that the bill be now read a second time. As many as of the opinion say aye.
Sorry. Just have clarification, please.
Mr. William.
Yes, thank you, Speaker. Clarification for Minister on his response regarding the extradition treaty with Indonesia. Basically, can I confirm that he's saying that as far as that is concerned, the terms of the bilateral treaty prevail over the bill in that sense? I mean, it's between the two countries to agree. The second clarification is, as I mentioned in the past, the interest was always to pursue fugitives who had fled Indonesia after the Asian financial crisis, which took place about 24 years ago. So is he saying that the Indonesians are now happy with just going back 18 years and they will just sort out whatever they need to do? I mean, can you clarify that?
I think 18 years is the agreed period of time with Indonesia in the treaty. As to how and to what end they want to use that and deal with fugitives arising from the AFC or otherwise, I think that's the call that they make. But on the terms of the treaty, it goes back 18 years. To your first point, the treaty contains the substantive obligations between the two states. I think I pointed out both in my opening speech as well as my reply to you that that is the principle. You look at the treaty and the terms of the treaty. And that governs the relationship between the two parties as to the terms on which you would extradite or not extradite, as the case might be. I perhaps want to just clarify one point which I think you alluded to earlier in your speech. When I said in my opening speech that there are some cases where you could widen, that might apply, for example, if your treaty is worded in a way which allows you to piggyback on what the laws might be amended to. So if your treaty says all offences which the state might now or at some stage revise your statutes to cover, then of course in such a scenario, because it's a moving definition in the extradition treaty, it moves along with any amendments or enhancements that the state might offer, like in this case. So if what was previously agreed is fixed at just 1 year imprisonment, you can only extradite for 1 year, then that will be a binding on the parties. But if one says it's for a period of time or whatever you might choose at some stage to amend your laws to, then the treaty would follow that provision. So in that scenario, it might widen. But otherwise, the principal point is that the treaty obligations between the parties will be binding on the parties.
Order. Leader, you might want to move for exempted business.
Mr. Speaker, I beg to move that the proceedings on the business set down on the order paper for today be exempted at this day's sitting from the provisions of Standing Order Number 2.
The question is, the motion as moved by the leader. As many as of the opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. Any other clarifications, please? The question is that the bill be now read a second time. As many as of the opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it.
Extradition Amendment Bill.
Committee stage, what day?
Now, sir, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as of the opinion say aye.
Aye.
To the contrary, say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 30 stand part of the bill. As many as of that opinion say aye.
Aye.
To the contrary, say no. I think the ayes have it. The ayes have it. Bill to be reported. Minister for Law.
Mr. Speaker, I beg to report that the bill has been considered in committee and agreed to without amendment.
Third reading, what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it.
Extradition Amendment Bill.